Hello, this is Thomas Kite, applying for the position advertised by the Attorney General's Department. Now, before we turn to issues surrounding the Australian Constitution and the integration of the First Nations voice, it is useful and necessary to firstly define what the First Nations voice actually is. Now, the Joint Select Committee released a final report in 2018 that calls for a representative body called the First Nations Voice, whose members are chosen by Aboriginal and Torres Strait Islander peoples to coexist at a state, federal and local level of government. Now, the First Nations voice would not veto, nor would it infringe upon the legislative powers of Parliament. It exists merely to provide input where legislative power turns on sections 5126, or the races power, and or sections 122, or the territories power of the Constitution. So therefore, the purpose of the First Nations voice is essentially to install a representative advisory body with constitutional recognition. Now, the introduction of the First Nations voice impacts upon all three arms of government in our separation of powers. The advice and input given to the First Nations voice would inform the Parliament as to appropriate legislative measures. The measures would then be enforced, as they are, by the executive government. And finally, the legislation and enforcement would be open to appeal and scrutiny through the hierarchy of the judicial system, with the High Court as the final avenue of reform and refinement. Now, in this manner, should a party with sufficient standing find fault with the statute or the execution of the statute, as well as subsequent judicial rulings, the legislation must run the gauntlet of all three arms of government in order to reach a final state. Now, the legislature, or parliament, is the arm of government concerned with creating new laws. It is crucial at any level of policy development that a solid understanding of how and why constitutional laws may or may not fit within the boundaries of the Constitution features prominently in the reasoning and formulation of new policies and or amendments to existing legislation. The wording of the constitutional amendments is also highly relevant. The interpretation of constitutional text itself is integral to judicial characterization of the impugned laws. The Australian High Court has typically adopted a kind of literalist and legalist approach, beginning with the Engineers case of 1920. However, the amendments proposed by the Uluru Statement demand further analysis and scepticism of these judicial traditions. Namely because the amendments demand a recognition and confer power to the indigenous populace that clearly was never intended by the framers. While cases of progressive interpretation are not common, there exists some judicial support for the approach, namely His Honour Justice Kirby's minority judgment in the case of Grain Pool of Western Australia and the Commonwealth. His Honour suggested interpreting the words as they are literally with an appropriate contemporary meaning. The desirability of this particular amendment, with reference to the established constitutional law norms and customs, is that the First Nations voice would not explicitly nor implicitly limit the power of Parliament. It would merely create an advisory board whose advice must be sought in certain circumstances. The executive branch of government, which is ours, this is comprised of cabinet ministers chosen from and responsible to the Parliament in enforcing new legislation and policies drafted by the legislature. It is imperative to realise that while the executive does not necessarily draft new legislation, it is still responsible for carrying out the law, and it is ultimately at the scrutiny of Parliament. Now, finally, we turn to the judiciary. Now, the judiciary is considered the ultimate guardian and enforcer of the rule of law, with the ability to both strike and read down impugned legislation. To use the words of the Marbury and Madison case, it is the duty of the court to say what the law actually is. It is here that we must anticipate future judicial challenges to laws made pursuant to the opposed amendments, as the High Court is the final authority in determining the validity of constitutional laws. It is also here that we may consider a route to enshrining the First Nations voice that does not initially include a referendum. That is Commonwealth legislation that essentially creates the same advisory body but is not enshrined in the Constitution. Now, in assessing potential judicial challenges, we first must begin with the characterization of the law. The process of characterization begins with firstly ascertaining whether or not the law in question is a purpose or subject matter power. Now, as the amendment would likely follow the format of all the existing races power, the First Nations voice would be considered a subject matter power. Furthermore, in the alternative, Commonwealth legislation to create the voice without the amendment would fall within the existing ambit of the race's power, or sections 5126 of the Constitution. We now consider the test of sufficient connection in characterising a law with, under a subject matter head of power. This test derives from the aforementioned case of Green Pool of Western Australia and the Commonwealth. We must ensure future legislation is consistent with constructing the constitutional text as broadly as possible, determining the character of the law with reference to the rights, powers, liabilities, duties and privileges it creates, examining the practical effect and the legal effect of the Commonwealth law to ensure a sufficient connection, the possibility of dual characterisation, and if such a sufficient connection exists, the intent of Parliament is irrelevant. Now, secondly, we turn to the capability of the proposed First Nations body being enshrined in our Constitution. Now, this is a question as to the ability of the Australian people to amend or alter the Constitution in the ways in which it is possible, and ultimately the philosophical underpinnings of why a Constitution is considered the apex of legislative power. Section 128 of the Constitution provides certain political requirements for the amendment's passage. Furthermore, it must be passed at a referendum with the express consent of the people as a whole. Now, public support for the First Nations voice is actually quite high, considered based on the evidence that tended to the Joint Committee by lawyer Shireen Morris. Next, we turn to the current Prime Minister's stated reasons against the First Nations voice, so that such a body, being elected with only a fraction of the populace, would not be in line with features of a representative democracy, or one with equal civic rights. Now, this rejection may be argued against firstly by acknowledging that the Constitution itself already permits, and has always permitted, the ability to legislate with respect to people of a certain race, on a racial basis. This provision cannot operate without denying a benefit to one race over another, clearly at odds with a society upholding equal civic rights. Now, one may argue that to rectify such hypocrisy, the sections of the Constitution that permit such racial discrimination ought to be repealed or amended. Now, in this light, we turn to the true source of constitutional legitimacy, the acceptance of the people. Now, should the First Nations voice find acceptance within our Constitution via a referendum, then it must be conceded that the will of the people carries with it the will for the Indigenous populace to achieve the right to representation at a national level. If the question is answered in the affirmative, this displays a society well aware and supportive of the rights of Indigenous peoples to be heard when Parliament attempts to legislate in ways that affect them and their connection to the land. That will be all from me today. I hope you've enjoyed my resume. Please don't hesitate to contact me.